I first want to welcome you to this really important panel on the state of our democracy now, and then looking forward about 2 weeks to the state of our democracy in 2 weeks. My name is Justin Levitt. I will be your friendly moderator for the session. I am a faculty member at Loyola Law School in Los Angeles. Starting all the way to the left, Professor Spencer Overton is the Patricia Roberts Harris Research Professor at GW. He has written an enormous amount of fancy things in fancy places. He served on the Obama transition and was the Principal Deputy Assistant Attorney General in the Office of Legal Policy at DOJ. He served as Commissioner on the Carter-Baker Commission. He is the outgoing President of the Joint Center. He served as an ACS board member. I could go on and on and on, but then we wouldn't get to hear anybody else say anything, so that's Spencer. Next to him, Poi Winnichakal is a senior staff attorney at the Southern Poverty Law Center. She has been working on voting rights all over the country, but particularly in Georgia, where there is never anything to do on voting rights. She has co-founded a coalition of state PACs in her previous life, supporting young candidates of color, which is tremendously important. She's worked at the FEC. She's worked at People for the American Way. She worked at the Brennan Center, although I regret I don't think we overlapped at all in the time, but just narrowly missed each other. Sitting immediately to my left, Dwell Ross is a Deputy Director of Litigation at the NAACP Legal Defense Fund, Incorporated. He has also written many fancy things in many fancy places. He leads LDF's litigation on school desegregation and elections. He has argued before the Supreme Court on at least one of the cases we're going to hear about today. These are all incredibly impressive people, and I want to leave you with time to actually hear from them. So I will pose questions and then shut up. I want to start in the center with Poi, just for a second. So in the next month or so, Poi, the Supreme Court may or may not decide a case with pretty huge implications for our democracy. Set up Moore versus Harper for us, and although the procedural posture of the case is impossible, essentially, what the heck happened?
So I'm going to give you the Thanksgiving dinner version of this. There are many esteemed honorables now who can give you the full recitation of the docket. But essentially, if you haven't heard about this before, Moore v. Harper is a case that is unusual in so many ways. We could spend so much time talking about this from various lenses, but just the basics. In North Carolina, they passed a congressional redistricting map after the 2020 census. And the North Carolina state constitution has a provision that basically says you can't partisan gerrymander. Now, that map, which heavily favored Republicans, was litigated in the state courts, and the state court said, you can't do this, it's partisan gerrymander. And then on the appeal to the Supreme Court, the state legislature, so Moore, we never talk about the people who actually bring these cases. Moore is the Speaker of the House of Representatives. He's the one who's the petitioner in this case. And he had said, we're just gonna go, this is how we're gonna take this appeal. We're gonna say that the state Supreme Court has no business deciding whether this is a partisan gerrymander or not, because the federal elections clause in our federal constitution, and I wrote this down because I don't have as good a memory as everyone else here. Article 1 of the elections clause says the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. And there's this other clause that they always forget, which is, but Congress may at any time by law make or alter such regulations except to the places of choosing the senators. So they're saying that the federal constitution has this clause that says, it doesn't say state courts, it doesn't say people, direct democracy. It says each state by the legislature thereof has power to choose time, place, manner regulations of anything related to federal elections. So because we're dealing with a congressional map here, only the legislature can decide whether this is a good enough map or not. That's, I think, the thing that maybe you can try to share with people who are not lawyers, and that's the gist of this case. Now, the problem with this is, what the hell? It is, where did this come from? Why were they able to just reach into the Constitution and make this up? In a few other, previously, when, we weren't going to talk about the procedural posture of this, but essentially we had 4 justices who invited this exact question earlier in a different posture in the case. And the legislature in North Carolina took the bait. And that's how this question actually came before the courts, because the justices invited it. So that probably, I'll stop there, because I know that there's lots more that we want to talk about, and others can chime in.
A tremendous amount to unpack in that, including there's a wrinkle which says that we might not get this opinion after all coming out in the next month. I want to get there in just a second. And as you noted, some participants in various ways sitting in the audience among us who are supremely well informed about the status of this case.
Supreme.
Indeed. But before we get there, I do want to point out, so that coming up to the Supreme Court of the United States is this notion that state legislatures not only don't have to listen to their state courts, but don't have to listen to their state constitutions at all when it comes to anything affecting a congressional election. And I just want to point out, or invite actually others on the panel to step in if they want, how unbelievably destabilizing that is, and how actually quite radical. This is well past a conservative notion. How profoundly radical it is to cut a legislature loose from its own state constitution and from its own state courts, as this doctrine would suggest. That's exactly as Poi said, how it comes up to the US Supreme Court. So before we talk about the wrinkle in this particular case for a moment, I'll invite other members of the panel, and Poi, if you want to follow up on this, you too. How does this actually work in practice in the redistricting zone, outside of the redistricting zone? If the Supreme Court takes the bait that Poi said, has been teed up for them, what should we expect next?
I'll say something. I think, perhaps the most extreme example of this could be if you can ignore a state constitution and the state legislature can decide, the rules for a federal election, you can potentially ignore the results of an election. You can essentially say, the state legislature is supreme, the state legislature can do whatever it wants with respect to how an election is conducted for federal purposes. Now, obviously, the Constitution restricts that, at least with respect to the House of Representatives and the Senate, but you can change thinking about how that applies to the elections clause related to presidential elections, which also gives the same kind of discretion to state legislatures. You don't necessarily have to abide by any state constitutional provision or state law that requires you to do a primary, general election, and then respect those results, right? And so it is, and perhaps on the less extreme side, it means that states can always change the rules for the election, no matter what their state constitution says, no matter what state law says, and no matter what a governor or a Supreme Court in the state says, and which is really sort of an inversion of the entire systems of checks and balances that we have, not only in our federal system, but in our state system as well.
Spencer's uncharacteristically. There we go.
It's so hard for me to take these folks seriously, right? Because if you look earlier in terms of this Rucho case, in terms of North Carolina, and hey, this excessive partisan gerrymander, and the U.S. Supreme Court says, hey, we don't have manageable standards. Lower court, you were wrong in terms of rejecting those maps. In this state where presidential elections are about 50-50 here, you were wrong. So, okay, you go to a state Supreme Court, and the state Supreme Court interprets a state constitution to say this extreme partisan gerrymandering is a problem, and now we have, this case. So it's difficult to see this as anything more than a power grab as opposed to the rule of law.
Yeah, I wish I had a dissenting view on that, but I don't. It's very true that, as Spencer said, the Supreme Court told federal courts back off because state courts got this handled. And now they seem poised to tell state courts back off because nobody got this handled. Because the legislature can do what it wants, when it wants, as it wants, unless it's violating the federal constitution. State rules don't matter anymore, is the theory. Now, I should point out, the Supreme Court has gotten to the brink here, looked over the edge, and stepped back before. Right? In Bush versus Gore, 3 votes, but not 5, for the proposition that, as Duell pointed out, the Article 2 version of this doctrine would hold sway. In the Arizona State Legislature case about whether the people could have a say in how congressional elections are held, passing a referendum to pull things into an independent redistricting commission, 4 votes, but not 5, said this is a step too far, cutting the legislature entirely out of the picture. There have been, I think as Point mentioned, sort of one-off concurrences in shadow docket cases, or 3-off concurrences in shadow docket cases that have said, we're intrigued by this rule, we want to hear more about this rule. And they're coming up to the brink, and they might not like what they see. So in addition to the ramifications for democracy of having a state legislature ignore its own state courts, talk a little bit about the practical impact of coming up on an election and not knowing whether the rules are the same for federal races and for state races on the same ballot.
Right.
Yeah, I can start there, and I'll talk a little bit about Georgia and how that would look. In Georgia, there's 159 counties. It's a ton of counties, and each of them runs an election. And that's how elections are primarily run county by county. There's some general, there's rules statewide, but really the actual administration happens in each county. If you say that the state legislature, which is a part-time state legislature, many of our states have part-time legislatures, had to interpret rules about an election, something that's not totally spelled out in statute, and they had to do it on the eve of election, how to count certain ballots if there's another pandemic, how to administer certain emergency procedures. That would be absolute chaos, not just to make the decisions, get a whole body. We have a really large state legislature as well, to have them make a decision, get together and make a decision, interpret this, and then disseminate information to all 159 counties, and then hopefully they administer it even in a particular way. That's best case scenario. That and that's in just considering a federal election.
Right.
Like there's still a level of that where in a state election, then that would be a different form of scheme of administration. I just, I could doom spiral forever, but that's just a very specific small example.
But just on that, you can have the same election, and some ballots will be counted for federal elections, and for state elections, and others may not be counted for federal elections. And how you explain that to people, same ballot, but this doesn't count for a federal election, but it does count for a state election.
Because the same statute, right?
Right.
It's just that for federal elections, that statute has to be interpreted in a way that ignores the state constitution and the state courts. And for state elections, there's no get-out-of-jail-free card. There's no escape clause. So that has to be interpreted in requirement with all the normal rules that come down from the state courts about how the statute's to be read. Sorry.
Right.
Oh, I was just going to say there's, even the fact that it says the way the Constitution reads, right, it's like it says state legislature. But how do you determine what that is, right? Is it what the state legislature says on Monday, or is it the fact that the state legislature is probably the one who in part set up the state courts the same way it is with the federal constitution, and set up the ways in which the election system is supposed to work for federal and state elections? And so that itself is also sort of confusing about what does it mean when you say state legislature? Does it mean those people who happen to meet on a particular Tuesday in November, or is it the people who have met over the course of the 200 years of this country's history and set up rules in a system that does involve both the governor, the state legislature, or the state courts and other systems?
So I want to come back to that point about the chaos ahead, but first with a note to timing, because there's a procedural wrinkle here. in that this case looked like, as Poi said, the Supreme Court, at least 4 justices, invited this case, rather explicitly, actually, and now seem to be in the middle of what could be a full-fledged Wile E. Coyote turnaround. Why?
Well, in the intervening time, the state Supreme Court in North Carolina, made up of elected Supreme Court justices, the composition has flipped, and so they have taken upon themselves to reverse their decision that the congressional map is no longer a partisan gerrymander. There's a more specific way to talk about that, but that's essentially the gist. And so the question is now, after supplemental briefing invited by the U.S. Supreme Court, whether or not they should make a decision. And I think the plaintiffs are split on that. There's, of course, kind of a procedural mootness question. Is the specific question before the Supreme Court still game? And I think that there's 2 camps to it. There's 3 sets of plaintiffs, and one of them says, go forth, you can still, this is still ripe, you should, the Supreme Court should make a decision on it, and then the others say no, including the Department of Justice. So, I mean, I think that there's probably valid arguments on both sides here. On the one hand, we've just talked about how this is endgame, and so it might not be great if the Supreme Court made a decision, but then on the other hand, the Supreme Court has invited this question repeatedly, and it may not totally be up to the plaintiffs, or I guess the respondents, we'll see what the Supreme Court wants to do.
So let me talk about just quickly the political implications. You all are probably aware, but let me lay it out, right? Under the map established by the North Carolina Supreme Court before, it was 7 Democrats and 7 Republicans. Basically, that's about right. Trump got 50% of the votes in North Carolina. It was 7-7, right? The new map could go, as opposed to being 50-50, could go to possibly 79% Republican here. It could be a situation eventually where, as opposed to 7-7, it's eventually, in terms of particular folks losing, it could be 11-3, which obviously has national implications in terms of the House of Representatives. And I have to do this. And this really, it's part fanboy admiration, right? But it's partly why people across the country in ACS are incredibly important in terms of democracy. I just want to read a line here from North Carolina Supreme Court Justice Anita Earls in her dissent here. I'm sorry.
No, good. I was going to do it if you weren't.
Okay. Our Constitution provides that, quote, all political power is vested and derived from the people. All government of right originates from the people. It is founded upon their will only. Quote, that's the Constitution she's quoting. Then she says, but when Republican lawmakers are free to gerrymander redistricting plans without constitutional guardrails to ensure their party's indefinite political domination here, or to constrain it, this constitutional requirement is abandoned, end of quote. The work you all do is incredibly important in terms of the future of democracy, and just thank you, Justice Earls, for your leadership.
So I will actually commend every word of that impassioned and lengthy dissent to any interested readers. For the masochists among you who are very interested in posing federal court stumpers to your classes someday, I will commend the briefing on whether this case is moot and or whether it should still, despite that, be heard. There are many different parties, each with a different point of view, some of which include, well, you didn't have jurisdiction before, but that didn't bother you then, so it shouldn't bother you now. Professor Overton mentioned that the new map could well be as heavily as 79% Republican in the congressional delegation. But I'll tell you, that depends on two things. One, the legislature's own sense of self-restraint, because there are no rules on how congressional districts have to be drawn except for the fact that they're a single member and the Voting Rights Act. So there are no contiguity rules about congressional districts in federal law anymore. Used to be, not anymore. So if you want to draw a district that looks like a smiley face, federal law doesn't constrain you except for the Voting Rights Act. So I think they can go well beyond 79% if they choose, and you'll have some strange looking districts in North Carolina. I said, except for the Voting Rights Act. This is an uplifting panel because we're coming to that. Duell.
Yeah.
This is not the only big case coming out of the Supreme Court, and though we're not sure whether the Supreme Court will rule on Harper or Moore in the next month, and if it doesn't, whether it'll tee up another case. There's some waiting in the wings in Ohio and elsewhere. We do know that they are poised to rule in the next month on what may well be the 10-year anniversary of Shelby County in a case called Merrill versus Milligan. How did we get here?
How did we get here? So we got here because Alabama is a state that has long had a large black population. Over the course of the last 10 years, the black population in Alabama and frankly the people of color population in Alabama has grown from, excuse me, and the black population is approximately 26-27% of the state, whereas the white population in Alabama has shrunk down to about 65% of the state's population. Alabama has 7 congressional districts, half the number of North Carolina. It's a small state. And for the last 30 years, Alabama has chosen to draw only one majority black district. I say chosen sort of lightly because they had to be sued, and there was a series of Section 5 objections in the 1990s that led them to that. But because the black population has grown and the white population has shrunk, a group of plaintiffs, including my client, Evan Milligan, the Alabama NAACP, Greater Birmingham Ministries, filed a lawsuit in late 2021 after Alabama enacted its new congressional map and kept just one majority black district, even though in the months leading up to the enactment of the bill, there were a number of proposals, including 2 majority black districts, districts that kept every single county in Alabama whole, didn't split a single county in Alabama, but created 2 opportunity districts for African American voters, which the Alabama legislature rejected. And so we filed a lawsuit under Section 2 of the Voting Rights Act, also under the 14th and 15th Amendments. A number of other plaintiffs, including a group of local attorneys and a group of other black voters, brought similar claims, also challenging the map. And the claims are essentially that Alabama should draw a second black district, that it shouldn't be the case in a state in which 65% of the population is white, that white people control 86% of the state's congressional maps, and they do so in a way that it's impossible, essentially because of racially polarized voting, because black voters and white voters in Alabama, both in Democratic and Republican primaries and in general elections, prefer different candidates, that black people are tending to vote for black candidates, and white people, regardless of the party, are voting for white candidates. And so we brought this lawsuit, that's sort of the background, and got 3 judges, 2 of whom were Trump appointees. And surprisingly, the judges moved very quickly to get us a hearing on our preliminary injunction, very quickly to issue a ruling in early or late January of 2022. And they found unanimously that Alabama's map violates Section 2 of the Voting Rights Act. They didn't do it just based on the proportionality that I talked about, but they did it based on the fact that if you look at this 3, 12, a lot of factor tests, that it was clear that Alabama's map violated Section 2.
And in a textbook opinion, I mean, this opinion is as careful a Voting Rights Act opinion as you will ever see.
Yes, and as both the district court said, I'm skipping one portion of it, which I think is really important. A portion of Alabama is called the Black Belt, which I won't get into, but it goes through the middle of the state. And what I think struck this panel of fairly conservative judges is that everyone in Alabama knows what the Black Belt is, and yet it is that region that the state has chosen to split for nearly the entire history of the state's existence. And doing so essentially has cut out representation for black people in in Congress in a way that's really meaningful. And so even though we got this wonderful opinion from this 3-judge panel, the Supreme Court stepped in and blocked it. Basically, Justice Kavanaugh, who wrote an opinion, said that it's too close to the election. The decision came out in January. The primary wasn't for 4 months. The general election, as we know, wasn't until November. And so we had a hearing, argument in October of last year on it. So I'll stop there.
So it's tough to confine the number of things to be angry about in this panel generally, and in these cases in particular, including the fact that now there is no time that is safe from the shadow docket and the Purcell principle before an election. We're right now in the throes of preparing for the 30-30 election. So 30-30 is what I said. What are the stakes at the Supreme Court now that we're here, now that the argument is here? What are the stakes for the argument they're hearing?
Sure. So I think one of the things that is interesting about Alabama's argument is that they're essentially, it's difficult to read their brief. I don't suggest doing it. But what they say over and over again is that, what they're trying to say over and over again is that any use of race in redistricting is unconstitutional. And if that's true, nearly every congressional state legislative map in the country is unconstitutional, because every district that it's drawn in this country considers race, not just for Section 2 compliance, but because that's a part of sort of the history of this country, right? And I think the thing that was sort of most compelling about this, the sort of ridiculousness from my perspective of Alabama's argument, is that our argument was that the Black Belt is a community of interest and that needs to be protected under Section 2. Alabama's argument to say that our proposed maps, which aren't even real, they're just things that experts drew, that include 2 majority Black districts, are unconstitutional racial gerrymanders. And the reason for saying that is because one of the things that our maps does is split the county of Mobile in Alabama. And Alabama's argument about why that's a racial gerrymander is, oh, well, you're splitting up the Spanish colonial heritage of Mobile and Baldwin, these 2 counties that are next together. So, we are using race because we're thinking about the rights of African Americans, but they don't think they're using race when they talk about Spanish, French, colonial people, right? Which is just not very good synonym for white people, right? And so I think that's sort of the danger is, obviously, if you say it's unconstitutional to think about race under the 14th Amendment in every instance, it's deeply problematic for every enforcing the Voting Rights Act going forward. One other thing I'll just touch on briefly is the other thing that Alabama is arguing is essentially that computer simulations, which the Supreme Court said in Rucho were gobbledygook, are now sort of the gold standard for whether or not you can draw a second majority Black district, which I can get into, or we can skip.
Well, Spencer's leaning forward, so I suspect there's an addition to be had.
Yeah, I just want to add a couple quick points in terms of voting is incredibly racially polarized in Alabama. Almost 80% of whites voted for Trump, for example, and almost 90% of Blacks voted for Biden here. There was some math in there, and I was a journalism major, so the simple math for me is that 2 of every 7 Alabama residents is Black, whereas only 1 of the 7 congressional districts in that original map is Black. And this is a trend that we see really throughout the South. And most Black folks don't even live in that district. Like 68% of Black folks have been basically divided up into these other congressional districts so that they can't elect a candidate of choice, so that they're unable to here. And so, Alabama is stark, but this is a problem really throughout the South. And if this test, if there is a new test in terms of jingles adopted, we talked about Alabama and their argument, but Alito has talked about, hey, what would an unbiased decision maker, what map would that person draw here, right? With an algorithm, really kind of a doorway to get intent into the test, even though that was rejected in 1982 in terms of the updates to the Voting Rights Act. But what's at stake is right now, about 30% of the congressional districts in our country are majority people of color, right? About 30% of them. That includes 40 majority Latino districts, 10 majority black districts, and about 2 majority Asian American districts, right? Those districts elect 81% of the Congressional Black Caucus. And I'm not saying like majority black, I'm talking about the majority people of color districts. 81% of the Congressional Black Caucus. 84% of the Congressional Hispanic Caucus comes from those districts, and 53% of the Congressional Hispanic Conference, which is the Republican Hispanic Caucus here. So if this test were to change, and if these voting rights protections were to be somehow diminished and these districts challenged, it could have a significant consequence in terms of, and that's just Congress, because the implications would be in terms of state legislatures and local legislatures as well.
Yeah, I just want to say one thing to maybe clarify both what Professor Overton and I am saying, which is basically that if you can't use race in redistricting, it's much more, and if you have to use something like computer simulations, which are easily manipulated to come out with whatever you want them to come out with. Sorry for those of you who I know use computer simulations in your cases, but then it's going to be very difficult for a state to draw, or even good states, right? Good quote unquote states who want to draw majority minority districts to do so in the future. And if the court changes the standard for Section 2 violations, it's also going to be difficult for states or for plaintiffs groups to bring cases to create majority minority districts, or even just effective districts where minorities have representation and where minority communities are represented in state legislatures, in Congress, in city councils, in county commissions, and school boards all across the country.
And by the way, to Duell's last point, judges in these cases have gotten by more or less with waving their hands at many of the simulations and the experts presented so far and saying, I don't really understand that, but I get that you're talking at me and I hear you. Stay tuned. If this becomes the new standard, there are going to be all kinds of fights about which experts get to testify about what and exactly how these models are built, and I don't think the courts are anywhere near ready for that at all.
And I'm sorry, there's also this variable of politicians hiding behind politics.
For sure.
Right, so this scenario where race and politics are so correlated in certain places, they just simply say, hey, we didn't consider race at all. This was just politics here, et cetera. And so, they don't have a district. It's not because they were black, it's, they're Democrats here. And so they don't get a district here.
Absolutely true. So we've given you a lot of food for thought for questions, which we'll be coming to in a moment. Before we do, I am constitutionally obligated to tell you your second CLE code, which I know is the only reason you've all been sitting here. That code, again, is ASH, A-S-H. First one was Cypress, C-Y-P-R-E-S-S. If you forget either one of those, come to me afterward, and I will tell you again. So I really do want you to be thinking about questions, because I really do want to have time for questions. But before we do that, with Professor Overton leading us off here, so we've just delivered a raft of potentially horrible news. Where do we go from here? Let's assume that the Supreme Court is poised to do some bad things again.
Right.
What do we do next?
Well, number one, I think it is important to realize that there is not a silver bullet in this situation. There are a variety of things that we could do, and these things have costs. There are benefits and there are costs to them, right? And so I'll just kind of go quickly through the list, and we can analyze them later in terms of discussion. Obviously, some kind of Voting Rights Act update could be some type of possibility. The challenge there is political. It's also the Supreme Court could somehow undermine that. The same issue with regard to passing state voting rights acts here. You could go with some type of mandated nonpartisan redistricting for federal elections. This gets into the earlier point, though, in terms of if you are completely race blind in terms of drawing districts, you could end up where many communities of color are underrepresented here, right? You could have a scenario where state Supreme Courts play a role in terms of interpreting their state constitutions here. The challenge, of course, is if the independent state legislature theory moves on, then effectively what you have to do is apply the state constitution to the state legislature, change the state legislature, and then have the state legislature redraw the federal congressional districts, which obviously is a mouthful. Something else, we've talked about it, but I just think it's so important that we are aligned the next time there is a tidal wave here is, or a tsunami, is SCOTUS reform. Just being prepared. I think people are in different places within our community on that. I think we really need to have discussions now so that when the window does open up, there is some degree of alignment and people are ready to move and aren't hesitating. I think a final piece that I'd lift up, and I'm still trying to kind of wrap my head around it, and it's some of the work we'll do at the Multiracial Democracy Project, is Lina Guinier and her work in terms of alternative voting systems where you don't have politicians basically sorting people, but people through their own agency are able to align and affiliate with different folks. And so in terms of that, we wouldn't be able to just amend federal law to eliminate the single member requirement, districting requirement, because some of these places in the South would just have at-large block voting, and there'd be no folks of color in seats, right? And so you'd have to replace it with something, and the question is, what is the system that's going to work best, that's going to be great for a multiracial democracy? A lot of folks are focused on partisan competition or partisan fairness and those issues, and those issues are important, but you know, racial equity is also important in terms of the future of multiracial democracy, and so we got to figure out what works well.
It's a good to-do list. Boy, anything to add to that list?
Yeah, I'll take the question in a slightly different direction, which is what can you do about all of this? We've spent a lot of time talking about the Supreme Court of the United States, 9 people who will change the direction of our country. They have the power to do that, and you know, let's be real about this. It's all about power. I think Sherilyn Ifill nailed that yesterday during her speech. We as lawyers, and I say this as someone who also litigates in federal court, we have more skills than litigation. And we should think about all the different ways that we can take action. We can, I was talking to a college friend last night at dinner, and we're like, yeah, I went to law school, so we didn't have to knock on any more doors. That's not true. You gotta knock on doors. That's knock on doors. Get out into the field, talk to people. I take trips down dirt roads that are really scary at night, and I show up and there's 2 people, and we talk about, you know, their dentist bills or whatever. But we do it because that's what matters to them, and then we talk about how that is part of representation. No one out there knows what ISLT is. Yeah. Right. And it's not ISLT. We should not call it ISLT. It's just about power. It's about a power grab. It's a formalism as a pretext for functional takeover. And we should talk about it that way. We should talk about it with people. We can door knock. We can get out the vote. And one of the things that I really love about voting as an issue is that it's a sword and a shield. Right? It makes such a huge impact because you're protecting the vote and you're encouraging people to vote for something. And that is we got to be all over the place, not just in the courts, and we got to think about alternatives to what we do to litigation. Hate to say it. But we really got to think about that, and that is part of how we are not just defending the rule of law, but also how we are building a rule of law with the people who it impacts the most.
I think that's a delightful yes and. Joel?
I don't think I have much more to add other than the Poy's wonderful statement, except to think about something that Sherilyn, since we're quoting her, often talks about, which is imagining the world in which you want. And I think all of this work in terms of like thinking about congressional work, knocking on doors, talking to people, finding out what they want, because that's ultimately what our jobs as lawyers are, is to implement what our clients want and not to just, come up with wacky theories or defend against wacky theories, right? And so, yeah, I really don't have much more to add to that except to say, to the extent any of you are doing civil rights work, any of you are doing any kind of work that's focused on trying to protect our democracy, is to really focus on, as Poy said, not just what's going on in the courtroom, but also what's going on in people's lives. I was just driving on several dirt roads on Monday and Tuesday, and I think that's a really important part of our work.
Spencer?
Yeah, and just to build on that, I think it's absolutely right. As opposed to just being reactive, this notion of us being proactive in terms of what is it that we're trying to create, right? There's some people in the past, they were dealing with a compromise between some slave-holding states and some non-slave-holding states, right? That was the past. Our challenge here is how do we build this multiracial democracy and move forward, and how do we come up with solutions to that, right? And that's not just a people of color versus white folks issue. That's a LA, Nuri Martinez, and how do different groups share power here. There are a lot of complex issues that we've got to work on together.
And I'll follow that up. It's exactly on point, and I think very much in line with what you've heard from the other panelists so far in the where do we go from here. Not just the Supreme Court. Yes, the Supreme Court, but not just the Supreme Court. Yes, Congress, but not just Congress. Mm-hmm. You heard about all of these doctrines putting an enormous amount of pressure on state legislatures, which means that state legislatures are a place that work desperately needs to be done, including with door knocking. And also municipal governments. You mentioned Nuri Martinez. LA is a state-sized municipal government. There are lots of municipal governments in the country, and there are lots of really innovative experiments, including with some of the alternative voting systems that Spencer's been talking about, that cities or towns or hamlets are implementing that we can take and use as models for other places in the country. So there's a lot to be learned on the local level as well. I would love to take your questions in the time that we have remaining. We need you to use the mic so that everybody can hear you. So please keep the questions crisp so that we can hear from the panelists and their responses. Please. Yes, sir.
Hi, thank you so much. If the Supreme Court embraces the independent state legislators theory, that would allow not just Republicans but Democrats to aggressively gerrymander. Do Democrats need to pass aggressive partisan gerrymanders just to keep up?
Team?
From my perspective, no. I mean, I think, to be very honest with you, right, like a lot of Alabama's map originated from more conservative Democrats trying to protect more conservative Democrats, right? And so, gerrymandering and partisan gerrymandering is something that can harm black voters when Democrats do it. As I said, thinking about Alabama, right, where primaries are racially polarized, that means that unless black people have a majority in a primary election, they can also be overridden by white Democrats, and they can lose representation that way. So I don't think, from my perspective, wholly leaning into partisan gerrymandering by states controlled by Democrats won't solve the problem that I'm trying to fix and won't lead to the world in which I'm trying to live in.
And I know this is a C3 panel, but if Democrats wanted more power than Republicans, then I would just say that's not even going to be enough. I don't think that Democrats would win that way. You can see how campaign finance has gone, and Democrats have tried to have super PACs the size of Republican super PACs, and they're not winning. So in addition to all of the good, moral, ethical things that Duell has shared and values that we share, I think that wouldn't even be enough.
I also think it's not necessarily what the people want. I mean, you look to states like Michigan, where there was an unbelievable outpouring of public participation in a citizens' referendum campaign in the dead of winter to tell the legislature, stop it. And I don't think that depended on the partisan label attached to the legislators. I think that was an instruction to the legislature, stop it. Abuse of power doesn't necessarily look better when it's got a friendlier "hello, my name is" sticker attached to it. And so I take both of these comments very seriously in that there's always somebody on the other side of that abuse of power. And a lot of them are, potential friends, and all of them are fellow Americans. Other questions? Yes, sir.
So, sort of related. I think that's behind this is there's a scheme of conservative Supreme Courts ignoring state constitutional anti-gerrymandering provisions. And I'll admit that asking creative arguments to the Supreme Court in favor of liberal initiatives is never that successful. But under the Contracts Clause, there's a rule that says look to state law to determine what a contract is, but you don't do it so deferentially that you allow the state to eviscerate the Contracts Clause. Is there another possibility to come up with some sort of argument that in order to protect elections and the constitutional rights to elections, that there needs to be perhaps deferential review, but review of state courts interpreting state laws to make sure they're following it?
So I think, I'm sorry, go ahead.
No, go ahead.
I think that's the pitch that was delivered to the court,
Right.
and it's a pitch a few of the justices at least seemed thrilled with, because they don't want zero rules.
Right.
And they also don't want to be up in every state decision. I mean, it's not just the notion that state Supreme Courts might strike down state legislative enactments. State courts interpret state statutes all the time because they are not always models of pristine clarity, sometimes intentionally. And every state court decision interpreting a state statute that has in some way to do with a congressional election now gets federal review if the court buys this theory. That means a bunch of election cases exploding on the Supreme Court's docket every election season. And I think that as much as the justices want power, they don't want power that looks like that constantly every 2 years. So I feel pretty sure that that escape valve exists if they're willing to see it. I will say it's awful hard to dip a toe into this pool and know when you are not swimming up to your neck. And so I don't pretend that there's any natural line that will actually stop the flood of cases coming the Supreme Court's way, because if they say there's a potential advantage to be gained in coming to federal court because you don't like what your state court has done, I don't see the stream of cases coming to federal court stopping anytime soon. Spencer also looked like he had something.
No, I would just say that obviously there are a lot of political thicket issues here that are not necessarily in other contexts, right? So that's there. And I would also say that some of the arguments have not been that nuanced kind of due process is a decision kind of arbitrary and capricious type of thing. Some of them are just, hey, you just have to defer to the state legislature, no questions asked, which I think is just extreme, right?
Yeah. Other questions? We got one in the back and one in the front. We'll go in the back first and then come back. Yes.
Thank you all so much for your excellent commentary. As you look ahead to the 2024 election, what do you see as the big potential legal issues that may arise in election law that could cause complications, and are there steps that can be taken to try to get ahead of them?
Ladies and gentlemen, any takers?
Herself?
You read my mind. That's the, so we haven't said a lot about, I mentioned Purcell, but I'll say so a little bit. So Purcell is a Supreme Court case from, I think, 2008 out of Arizona, in which a district court had denied a preliminary injunction against a voter ID law. The Ninth Circuit in basically no opinion, reversed, and the Supreme Court reinstated the voter ID law and said, well, it's too confusing with these conflicting lower court orders what to do, and so we'll just put the state law in place. And the Supreme Court, over the course of the last 15 years, has sort of taken that doctrine of we don't want voter confusion about changes in the law too close to the election, and to sort of put that on hyperdrive. As I mentioned in our case, even though it was 4 months before the primary, even though the district court had stayed implementation or the candidate filing deadline, the Supreme Court said 4 months before a primary and 10 months before a general election that it was too close to an election. Similar situation, and we had a case in Louisiana in which the district court found a Section 2 violation. The Fifth Circuit, of all things, denied a stay and said plaintiffs are likely to win. And then it went to the Supreme Court, and the Supreme Court said, well, Milligan's coming up, and it might be too close to the election, right? And similarly, I think it was 5 months from the primary, then 6 or 7 months from the general election, because of the weird way in which Louisiana does its primaries. So
I don't think they said anything. That's one of the weird things about these cases.
Yeah. In Louisiana, they didn't say anything. And during COVID-19 in 2020, I made multiple trips to the Supreme Court where they told me that Alabama didn't have a law against curbside voting. The district court had enjoined the Secretary of State of Alabama from enforcing a law that didn't exist, and the Supreme Court said, well, it's too close to the election to change a law that doesn't exist when people are ready and willing to do curbside voting in local elections. And so that issue of Purcell, the Supreme Court stepping in and saying it's too close to the election to change things, even laws that don't exist, is an issue that continues to come up in voting rights litigation. I think you'll see more of in 2024, unfortunately.
Boy? I'm sorry.
Go ahead, Boy.
No, I wake up thinking about Purcell every day, and I'd be curious. There's so many voting rights lawyers out here who hasn't been Purcelled at this rate. That's how ridiculous this doctrine is. But yes, that is my number one concern.
Just quickly, I think we'll see ripen issues of like the election interference in terms of state legislatures displacing local elected officials, and those officials making different decisions here, especially in the South. I also think this enhanced litigation to challenge voter access before an election and kind of throughout, I think that will continue to kind of ramp up, and we'll see it in a presidential election. I think we saw it to some extent in the midterms, and I think that we'll see it ramp up in 2024.
Two very quick thoughts, and then I want to come over to this other question here. On Purcell, I was a little flip with Duell. The Supreme Court doesn't explain itself in these opinions. The only thing we get are concurring statements, right? These are usually per curiam one-sentence orders that says the decision below is stayed, sometimes stayed pending cert, sometimes stayed just flat out. And then occasionally you get a justice or two willing to pull back the curtain a little bit to let you know what that justice was thinking. But these decisions don't make law, which has left lower courts horribly confused about when they're supposed to grant these stays and when they're not. Part of the problem with the doctrine is that the Supreme Court hasn't explained itself since the original Purcell case on what the rules really are. And so everybody's left to read tea leaves differently about when cases are supposed to go forward and when too close really means stop. The other, in response to the question, what are we going to see coming up? So we now have an environment that rewards election litigation with fundraising potential, even when that litigation is not serious. And we have an environment in which the Supreme Court, and particularly individual justices on the Supreme Court, are willing to comment about cases they'd like to see without offering clarity about whether cases should go or stop. We've got yellow lights everywhere, and sometimes half green lights, but no real green lights and no real red lights, and lots of litigation. So I'm going to tell you, the thing that's going to throw the 2024 election into complete chaos, we don't know what it is yet. It's any of the cases that have the potential to land at the Supreme Court in the first week of November. Or, even more horrifying, the second week of November. We have time for one more question. I'd like to invite, if there are women in the audience who have a question, if I can encourage you all to make it known. Otherwise, we'll be available afterward. We had a question that was living somewhere in here. Yes, please. Microphone coming your way.
The Supreme Court seems unlikely to welcome pro-democracy lawsuits in the near future. Congress has been unwilling or unable to pass pro-democracy legislation. So, Professor Levitt, what, if anything, can the executive branch do to improve the way democracy functions in our country?
Delightful question for me. Thank you. I'll find you afterward and thank you properly. So, for a lot of very good reasons, it's not the executive branch's job to fix democracy. And that is something that this executive branch has taken extremely seriously, because it wasn't that long ago that we had an executive branch that was confused about that. And that doesn't actually bode well. There aren't a lot of tools available for the president or the White House. DOJ has some tools. DOJ uses those tools. I might wish they would use those tools a little more aggressively. And there are lots of things that agencies are doing, but they're long-term. They're not short-term. They're wonderful, and I applaud all the work that federal agencies are doing to make information about voting more prominent, to make access to voting easier for all of the different ways that citizens interact with the executive branch. The president put forth a budget that actually would get elections funded for the first time, sustainably, predictably, reliably, right? We had an investment of money in 2002 after a crisis. We shouldn't wait until the bridges actually go out to fund building the bridges again. The president put forth a budget. Congress gave it the middle finger, essentially. There aren't a lot of things that the president or the executive branch can do on their own, and I happen to think long-term structurally, that's a good thing. I would look to local democracy if the federal government doesn't seem to be working for the people at the moment. I would look to local democracy as the place where more is possible, if only because it is sometimes easier for them to hear us, we the people, when we make our voices known, than it is for folks down the street to hear us. Federal intervention is going to be longer term, it's going to take more doing, and it's going to be by design slower, so that it is less possible to derail. And I take the safeguards against derailment actually extremely seriously for what the federal government can or should be doing in the executive branch alone. But there may be other thoughts on the panel.
I'm defer to you on this question.
The answer is not nothing. But the steps are slow and structural rather than revolutionary and tomorrow. Inevitably, I think. With that, I think we are 30 seconds over our appointed time, and I have promised to let you all out on time. Thank you so much for being with us today. If you need CLE, talk to me again. Please thank the panel.